5, 6, and rules for finance, Mr. H. Alia for respondent 3 and 7. Since the respondent the representative. Black. Last 8 months, he has been transferred for the third time, my lord. Also, may kindly turn to page number 15. Annexure 1 of my petition, my lord. This was on 19/6/2025. Also, may kindly turn to page number 16. The relevant order. So, Refugee Zaman, the petitioner, he was promoted as enforcement inspector and fast transfer from Gwalpara to Dhubri. This was in June 2000. You are reading page number 15. I am presently reading 16, my lord. 16. Yes. He is the petitioner. Yes, he is the petitioner. He was promoted to officiate as enforcement inspector under regulations and so. And my lord, he was transferred from Gwalpara to Dhubri first, my lord. And he joined. Thereafter, my lord, at page 18, annexure 3. This was on 13th of December 2025. After 6 months. Document kindly turn to page number 19. Order. How is it after 6 months? The transfer order is issued on 19/6. Yes. Page number 16. Yes, my lord. And this is on 13/12. You are reading from page number 18. 18. 13/12. Relevant is at page number 19, my lord. 19. Order number ending with 81J, my lord. Okay. The middle, Refugee Zaman. He was transferred on attachment basis to Kokrazar. This time from Dhubri to Kokrazar. He joined there also, my lord. While officiating, my lord, he was then transferred to Karbi Anglong. Lordship, may kindly turn to page number 24, annexure 5. Okay. Immediately after 2 months. Not even 2 months, my lord, 1.5 months. Order dated 2026. It is order number 1567, my lord, ending with 173E. Second one. Now, my lord, he has been transferred and kindly read the, may I read the order, my lord. The partial modification of the earlier government notification number so and in the interest of public service, the attachment order of Refugee Zaman Enforcement Inspector in the office of the District Transport Officer and Secretary RTA Dhubri as Enforcement Inspector of the Office of District Transport Secretary is hereby withdrawn, and he is hereby attached as Enforcement Inspector in the office of the District Transport Officer and so West Karbi Anglong with immediate effect. In addition to his normal duties as enforcement inspector in the office of the district transport officer at Dhubri. Now, my lord, I have to work at Dhubri also and West Karbi Anglong. And distance between both the offices is about 500 meters. But respecting this, my lord, I went to West Karbi Anglong 100, my lord, to join. But interestingly, my lord, there is no office establishment of DPO. It's a non-existent office, my lord. It's not functioning. So, my lord, I had to. Also, may kindly turn to now, my lord, page number 9, 29, annexure 9. As there was no office, my lord, on 11/2/2026, I submitted my joining to the district. So, this is to the district commissioner, my lord. Kindly see the receipt, my lord, received at the head assistant of district commissioner Hamred. So, thereafter, I wrote a representation to the authorities, my lord, as there is no office in Hamren, I may be allowed to work at Dhubri. And finally, I returned on 12th of February, my lord, to my original place at Dhubri. But, my lord, subsequent thereto, pursuant to my representation, which lordship will find at page 31, annexure 10, they have issued now, my lord, second corrigendum. Thereby, my lord, my posting at Dhubri has been cancelled now. Corrigendum was passed on 14th of March. That is at page number 39, annexure 13. This corrigendum was in connection in modification of the earlier order. What has happened?
Lordship, may I submit, my lord? Lordship, may kindly have a look, page 16. Order issued on 19/6/2025. Relevant portion is page 16. May I read the order, Lordship? Lordship, the subject to reversal without prior notice and assigning any region thereof, Mr. Refugee Zaman, senior assistant, is promoted to officiate as enforcement inspector under regulation such and such. So, Lordship, this is his promotional transfer. He was promoted from senior assistant to enforcement inspector. So he has been promoted and transferred to Dhubri. He is posted in officer enforcement in the office of the district officer Dhubri Lordship. So this is promotional transfer, the first one. Then the Lordship may kindly have a look page 19. Page 19.
Yes.
Lordship, 81J. May I read, my lord? In the interest of public service, Sri Rafiqul Zaman, Enforcement Inspector in the Office of the District Transport Officer and Secretary to RTA Dhubri, is also attached as Enforcement Inspector in the Office of the Transport Officer, Secretary RTA Kokrajar with immediate effect. It is an attachment order, Lordship, not the transfer order. The petitioner is projected. This is a transfer order. He has been attached along with the Office of the along the other works of DTO Dhubri and as well as the Kokrajar. It's an attachment order, not a transfer order. Then the page 24, my lord. Page 24, my lord. Six paragraph, my lord, regarding the petitioner. Page 24. Lordship, may I read, my lord? In partial modification of the earlier government notification dated 13/12/25 and the interest of public service, the attachment order of Sri Rafiqul Zaman, Enforcement Inspector in the Office of the District Transport Officer, Secretary RTA Dhubri, as Enforcement Inspector, the Office of the District Transport Officer, Secretary Kokrajar is hereby withdrawn, and he is hereby attached as Secretary RTA West Karbi Anglong with immediate effect, in addition to his normal duties as Enforcement Inspector in the Office of the District Transport Officer, RTA Dhubri. Then one corrigendum has been issued by the department on 14/3/2026. The Lordship will find it page 39. Lordship, page 39, the last page. So, may I read my corrigendum? Page 39. He shall draw his please read as he shall draw his salary from the Office of the District Transport Officer, Secretary RTA Dhubri, instead of in addition to his normal duties as Enforcement Inspector in the Office of the District Transport Officer and Secretary RTA Dhubri, in respect of Sri Rafiqul Zaman, Enforcement Inspector, as appear in the notification dated dated 2/2/2026. So, Lordship, after that he has joined in the his transport post place as Hamren, West Karbi Anglong, and after he has written on representation before the Office of the Commissioner of Transport, my lord. In the meantime, Lordship, I have just received one instruction. In the representation, he has alleged that there is no Office of the District Transport Officer in the West Karbi Anglong, Hamren. But Lordship, there is a photograph on 28th of February. The office was inaugurated, my lord. Just now I have received. Now the office is...
Why are you attaching him and asking him? Why are you attaching him in West Karbi Anglong? Asking him to draw his salary.
This is not attachment order. Now he transferred to Hamren, my lord.
Where is that transport?
Then the corrigendum is, Lordship.
Draw his salary.
Yes, Lordship, the page 24, my lord.
By this kind of original
Page 24, my lord. Order dated 2/2/2026.
He is attached as Enforcement Inspector.
Enforcement Inspector in the Office of the
In
RTA
addition
Dhubri,
to normal duties.
Secretary Kokrajar hereby withdrawn. This additional duty has been withdrawn, my lord. Attachment with DTO Kokrajar is withdrawn, and he has been transferred to Hamren, West Karbi Anglong.
Where is that order of transfer?
Yes, Lordship, page 24.
24 is attachment order is withdrawn.
Yes,
And
Lordship.
he is attached.
Yes,
He is
my lord.
attached. He is not transferred. He is attached. He is hereby attached.
And he is hereby attached as Enforcement Inspector in the Office of the District Transport Officer and Secretary RTA West Karbi Anglong with immediate effect, in addition to his normal duties as Enforcement Inspector in the Office of the District Transport Officer,
Now,
RTA Dhubri.
now you read the origin.
Page 13. He shall draw his please read as he shall draw his salary from the Office of the District Transport Officer and Secretary RTA Dhubri, instead of in addition to his normal duties.
Why he shall draw his salary when he is posted in West Karbi Anglong?
That instruction, Lordship, I will get, but as per his petition that has filed before this authority, he has said there is no office, DTO office in
Get
the
the office you have inaugurated very well.
Yes.
Good thing you have done. But tell us one
Lordship, I will
earthly
get the
reason
instruction.
why a man is posted in West Karbi Anglong and you ask him to draw salary from Dhubri.
That instruction I will get.
That is the most important
lord.
instruction.
I will get
When do you get it?
immediately after visit.
Immediately.
Immediately.
That my lord, I have no office to go and no office to
No,
They,
there is
they've given
office.
a beautiful photograph.
Yes.
See if you can find yourself.
On 28th of February.
My lord, facts remains, my lord, there was a DPO who is officiating to my instruction, my lord, from Diffu. That is again, my lord, around 200, 300 kilometers.
Mr. T.R. Sharma.
My lord,
Sport Department.
Response number 1 to 5, 1 to 3.
Then the 1 5 and Mr. A, and there's 6. Missionary alleging frequent transfer in a span of 3 years.
3 times.
8 months.
In 8 months, you were transferred 3 times.
Frequent transfer. Within a span of 8 months, he was transferred 3 times. Presently posted in Bren as enforcement inspector.
My lord.
While he's asked to draw his salary. So the district transport officer and secretary RTA. Commits Ms. Bora to apprise as to why the person is attached in the district of West Karbi Anglong, while he's required to draw his salary from the DTO and secretary in the district of Hubli.
Present them dated 14/3/2026.
Lordship may not state this at
Because I
this
will
stage,
be
my lord,
sitting
because
at
the
the-
election is coming,
What
officers
happens
required,
if
my
the
lord.
corrigendum is stayed?
Well, then I will be officiating. I will be able to officiate at Dhubri, my lord. Presently, I have no office to join. I have no office to attend. And more so, my lord, I am retiring in coming 2 years, my lord. I have stated, my lord.
Lordship.
February 28 is the date of my retirement. On the first of my retirement, my lord, if these things happens, this may, my lord, affect my pension.
No. This corrigendum will not have the effect on the order at page 24.
No, my lord. It will have, my lord.
How?
My lord, the corrigendum is in respect of the order dated 2/2026. That is at page 24.
Correct. But the order at the page 24
Yes, my lord.
is that you are posted in West, you are attached in West Karbi Anglong,
In addition to my regular duties
in addition to
Hubli.
your regular duties.
at Dhubri. By this corrigendum, my lord, my regular duty at Dhubri has been deleted. Now I will draw my salary from Dhubri only. If
Ah.
it is stayed, my lord, then I will be able to officiate at Dhubri. In addition to, my lord, non-attachment, as there is no office officiating.
When can you get it?
Lordship immediately after vacation. Immediately.
Immediately after vacation.
On
We'll stay
20th,
the
my lord.
order.
Yeah, Lordship may not, let's may kindly fix the matter tomorrow.
Get it.
Tomorrow. Otherwise, election is coming, Lordship, we are need the manpower. Saying this order hampered.
Submitted by the council that she would like to obtain instructions to please taken.
Public.
Deeply obliged.
Council for petitioner will furnish extra copies on the
Yeah.
respondent during the course of the day.
I'm up.
Obliged.
Artfed, is there a council?
Yes.
There is a council.
In other matters, one pays
Have you served copies?
before finding
Art council for party issue notice. Banerjee. He is responsible for 1 and 3. Items. Steps on respondents. The directorate also, you will hear steps on respondent 6 by speed post within 1 week. Step. Extra copies be furnished within 1 week.
Was petitioner joined as a join petitioner joined in ONGC service on 10 to 1982 lot. And he was retired from service 2019 lot. And he had applied 1/3 commutation amount under his retirement benefit scheme from the ONGC lot.
Any standing counsel for ONGC?
Yes, Lord.
Is there a counsel for ONGC? Any advocate for ONGC?
Yes, Lord. He does not.
Huh?
He does not.
Have you given him a copy?
Actually, Lordship, before filing the petition, Lordship, I have served the copy, but they have not received. He want to
Heard-
say that
heard
copy issued
Mr.
after I have taken the.
Mr. Steps on the respondents. The respondent by speed post.
I will.
The dismissal from service. Appeal file appeal also.
Yes, for one, half for 1, 3, 5. Seven. Respondent 1, 5 and 7. Okay, now the rest of all. Steps on respondent 6 by speed post. In 1 week. You want to take Dusty?
No,
It's taken now.
obliged.
Yes. I'm agreed by appointment of respondent number 3. But it's a prima facie patently illegal order, so Lordship will kindly come to the advertisement. Let's come to page 21. Now we are concerned with this post. Superintendent serial number 4 on top. Superintending engineer pipeline T&I. There are 5 number of posts. We are concerned with the post meant for SC. Then Milord will kindly come to page 24. This is how, Milord, this selection is to take place. Candidates will be called for computer-based test solely on the basis of their declaration in the online application form. Subsequently,
And this Lordship, in these matters, they have been led by senior counsel, Sir Gyal.
every time it's difficult.
When? Huh? When is
Pass
it
over
coming?
time.
Huh?
He's coming.
I'll take some time. You can come in. Candidates will be called for computer-based tests solely on the basis of their declaration in the online application form. Subsequently, eligible shortlisted candidates based on CBT result will be called to appear for a personal interview. That means, Milord, first there will be a computer-based test followed by, Milord, interview. Now, for computer-based test, the marks is 100, but weightage will be 85. And to qualify for interview as a scheduled caste candidate,
the candidate must get 40%. And similarly, my lord, 15 marks is the interview, weightage will be 15%, and there is no qualifying. If your lordship would kindly come to Roman 4, my lord. Merit list of the candidates shall be drawn based on combined weighted marks of computer-based test and personal interview as per defined weightage. That means, my lord, aggregate of both will be taken note of. Now, please come to para 8 of the petition, my lord. Admittedly, my lord, I have got more marks. That the petitioner, after coming to learn about the marks obtained by the petitioner, and the respondent number 3 had calculated the marks as per clause F of the advertisement. As per clause F1 of the advertisement, 85% weightage shall be given out of the total marks scored by candidate in computer-based test, and 15% weightage out of the total marks scored in the personal interview shall be given to the candidate. In the instant case, the petitioner has scored 48.5. My lord, I filed an application under RTI. Based on that, it was provided to and we've annexed also. So there is no dispute that I scored 48.75 in computer-based and 5 marks in personal. As such, 85% of 48.75 will be 41.43 marks, whereas 15% of 5 will be 0.75. In view of the above, the calculation, the petitioner has scored 41.43 plus so and so is equal to 41.68. As far as the respondent number is concerned, my lord, kindly see that after 2 lines, as per clause F1 of the advertisement, total mark of the respondent number 3 in the computer-based test will be 85% of 42, that is 36.12, whereas 15% of 12 will be 1.18. As such, the total marks scored by the respondent will be 36.12 is equal to so. So, my lord, respondent number 3's mark is 37.92 and my mark is 41.68. Now I have been denied appointment. And when we filed an RTI application, my lord, it was given to us. Please come to page 34. Page 34. So on the right hand side, my lord, marks obtained by roll number, the last number is 12, is 48.75. Then cutoff mark so and so. Then my lord, marks obtained by roll number so and so in the personal interviews 5, that is me. Then total marks of candidates for call for interview for the post of superintendent 3. Marks obtained in CBTT and personal by provisionally selected candidate under SC category 42.50 and 12.
You belong to which category?
Schedule.
Yes, and the private respondent also.
Yes. Well, admittedly, I secured 41.68 and respondent number 3 secured 37.9.
Still on legs.
Or lordship can do one thing, notice lordship can issue the notice today, keep it for interim orders on the exam, let them appear.
Take the end of it. Candidature. Superintending. Superintending engineer.
Yes, my lord. Pipeline.
Pipeline.
And T and I.
T and I. Right. Marks. Then the private response. Despite of that, marks scored by the private response. Such circumstances. criteria mentioned.
The 9th of April.
29 people. It's Mr. Santam, represents respondent 1 and 2. Steps on respondent 3 by speed post movement.
And we may be permitted dusty also.
Steps by trustee is also permitted, provided it is read through the registry of the court. Thank you. Prayer for inquiry. Consider. Next.
Deep dusty.
Yes. Caveat also. There is a caveat.
My lord, I am for the caveat only.
Kali Sai, so that is your. Caveat, Mr. Here. Caveat. Yes.
Make the motion. In substance, my lord, I'm to retire in the month of November. But since they have the
You were,
liberty,
stayed in Golaghat.
Now-
There you were,
no, I was not from there. The earlier order, my lord, they had maintained. Lordship would find that page 109.
1-0. You are appearing for respondent, Mr. Bhuya is for respondent 7.
My lord, for the victim, my lord,
Claimant,
complainant,
complainant.
my lord.
So it would be from Golaghat.
Hmm.
And I must be honest, my lord, since my suspension was revoked on the count that within the previous statutory period, maybe it was reviewed, no charge sheet was issued. Therefore, they certainly do have the right to statement and transfer. That would be too far if I address them. Now, what I was praying is that from Sribhumi, there are neighboring districts from where you get posting. On this count, my lord order at page 114 was a direction to the authorities to follow the representation, pass a speaking order. That's at 114 in substance. And liberty was also granted to the league that you may also participate therein. We did not object to that. Remember, we represented at page 118, 26th of March. 15 things were, but at page 119, paragraph 8, if I may read that part.
They want you out of the valley.
So now things are a little bit more serious than that. Whether I'm out or in, November I'm out of service. They can proceed against me. I'm not on that. Kindly see the way it has been crafted. Page 119, I say that 10 out of 13 posts of senior UD assistant are vacant in the district of Kachar, 6 out of 8 posts in Sribhumi, and 4 in Hailakandi. So if
You were an UD assistant,
you can
governed by
post,
the ministerial service.
so you can have me there if you want to. So basically, I am not on the legality of the transfer, but I'm praying for a softer accommodation, considering my health at around 60 years or nearby. Now, they refused that at page 122. They refused that and they maintained the earlier order of transfer. But
notwithstanding the grounds on which they refused, something else happened. At page 122, if I may read, Lordship permits me. Whereas Shahabuddin UDA serving as UD so and so was placed under suspension with a complaint of sexual harassment. Whereas the suspension order was set aside by the Honorable Court and Shahabuddin Chaudhary was reinstated in service. Whereas upon reinstatement, Shahabuddin was transferred to Additional Chief Medical Health Officer Golaghat by so and so. Whereas Shahabuddin Chaudhary submitted representation 6316. Whereas Honorable Court, while disposing of the writ petition 1490, that's my Lord's order, in this connection, directed Director of Health Service to consider representation now. That is more important. Whereas the complainant has also submitted representation 2226 to the modification of transfer order. That's my part. Now they say, whereas the earlier proceedings conducted by the Internal Complaints Committee, culminating in its report dated 18/3/2005, has been abandoned and a fresh inquiry by the ICC has been instructed by order dated 31/3/2026. Pausing here for a moment. After a year of that inquiry report, which says there is no
1 week, nothing.
that the Royal Council, my
We
friend,
don't know. You actually effectively think that in 1 week the inquiry will be completed.
but if the matter having been placed before this honorable court, if the interim protect status quo till next date, on the proceeding, if they started,
You satisfy us that the is prohibited.
de novo is prohibited, is not my argument. What I'm trying to address, Your Lordship, is that at page 121, it's a one-liner. 131/3/2026. It's a one-liner.
Fresh inquiry.
Whereas earlier inquiry proceeding initiated by Internal Complaints Committee was procedurally incorrect and has not been conducted in compliance with the provisions of the Sexual Harassment Workplace. And no more. Now, if I may invite my Lord's attention to the Act and the rules, how it is to be conducted. If Lordship would have the rules of 2013, which would be at page 22. Then about Rule 7. Rule 7, if I may read that. Manner of inquiry into complaint. 1. Subject to the provisions of section 11, at the time of filing of the complaint, the complainant shall submit to the Complaints Committee 6 copies of complaint along with supporting documents and the names and addresses of the witnesses. On receipt of the complaint, the Complaints Committee shall send one of the complaints copies received from the aggrieved woman under so and so to the respondent within 7 working days. The respondent shall file his reply to the complainant along with his list of documents, the names and addresses of witness with the period not exceeding 10 working days from the date of receipt of the documents specified under Sub-Rule 1. The Complaints Committee shall make inquiry into the complaint in accordance with the principles of natural justice. The Complaints Committee shall have the right to terminate the inquiry proceedings or to give ex parte decision on the complaint if the complainant or respondent fails without sufficient notice to present herself or himself for 3 consecutive hearings convened by the chairperson or the presiding officer as the case may be, provided that such termination or ex parte order may not be passed without giving a notice in writing 15 days in advance to the party concerned, and the parties shall not be allowed to bring in legal practitioner to represent them in their case at any stage of the proceeding before the Complaints Committee. In conducting the inquiry, minimum of 3 members of the Complaints Committee, including the presiding officer or the chairperson as the case may be, shall be present. Well, procedurally, it was followed. And if Lordship would kindly have Rule 11. Rule 11. May I read that? Subject to the provisions of Section 18, any person aggrieved from the recommendations made under subsection 2 of Section 13 or under clause 1 or clause 2 of subsection 3 of Section 13 or subsection 1 or subsection 2 of Section 14 or Section 17 or non-implementation of such recommendations may prefer an appeal to the appellate authority notified under clause A of Section 2 of so. My Lord, the lady has accepted the inquiry report and has not filed or preferred any appeal. Now the lady is happy with it. She's objecting.
Not a case of appeal, because it is not a logical order.
It is.
Ah.
Prepare for number 2 also, Mr. Speak to me. 5, 6. 7. Senior assistant. Filed an allegation, sexual harassment. Proceedings by the ICC will be initial. ICC inquiry did not result in finding lack of evidence.
No,
Because lack of evidence and non-participation of the petitioner himself.
the answer is lack of
Why?
evidence.
Matter was referred to state department. So the administrative department meanwhile is still the departmental proceedings under the Assam. State. See number
6765.
6765
Of
2025.
2025.
It is so suspended. I think by filing the WTC 416 of 2025. The order of suspension was interfered with by judgment dated 17/12/20. And the state definitely say order passed. Huh?
First, reinstatement and transfer.
Where is that order? Page
That's
number?
page 109.
So the edition is medical. And this order again challenged.
1495.
1495 or 2026. The dated 16/3/2026. Disposal of the petition. Directing the respondent authorities to look into the grievances. Three. Pass an appropriate order. Requesting for the transfer to by disposing of said petition. I didn't do it. Seeking treatment of the petition and raise the objection. Say no. Case of the petition, Navi, intention, and the authority rejected the six by the petitioner and six sustained. Reinstated. 1 4 1 2026. Besides sustaining the earlier order of transfer, as also
That is at page 121
you're challenging that also.
in the next page.
Submits. So, this to be interfered with as the petitioner is suffering from health ailments and is renovating in the month of November.
November. And I'm willing to go to the nearby districts at page 119 and set the post of vacant.
2026 and indicated vacancies available nearby districts. We pass a common order in both the districts.
Only one submission, one line I may be recalling. That although the plaintiff is objecting to the place of transfer, rightly wrong, per se to the entire report, there is no challenge by way of appeal as under the Act.
One, is it?
31(3).
1/3/2026, whereby there is no fresh inquiry. By conducting fresh inquiry. This in the very by the ICC is latter part. The complainant, private school, never raised any of this. The ICC, whereby the ICC submitted finding lack of evidence. And yeah, it's correctly applied its model and has come to a finding that the apprehension expressed by the private respondent regarding the possibility of influence interference by the petitioner cannot be facts and circumstances of the district for transfer to a nearby district. So, the claim and the This is. Study and here. Council appearing in private submits that. And unless the petitioner and therefore rightly transfer the transferred into district of Gauhati so that he will have no influence for any of the witnesses. Where was he earlier posted?
Not
Three
three only,
Three
current
only,
three.
at the nearby district.
Now, I have another submission more, my lord. Regarding the appeal of part, my lord, which my learned senior has raised. Appeal says, my lord, any person aggrieved from recommendation made under subsection 2 of section 13 under clause 2 and so. So, my lord, the ICC, my lord, which has been concluded, there was no any recommendations can be made because of, my lord, non-participation of the petitioner as well as, my lord, the lack of evidence. So, therefore, my lord, it has been closed. So, therefore, as no recommendation, scope of appeal was never there.
Therefore, 24th of April. Therefore, interim be considered. Date and time in the next. 765 or 20.
Fourth of May, my lord.
24th April.
Well,
We are giving you liberty to renew your prayer on 20.
He did not insist on me leaving station because they pressure.
We don't know. We are not staying. We are not giving a stay like that.
apply. I'll
Item number 16, Lordship was pleased to issue notice. I could not appear because I was in court number 1.
In recording.
My name and was also in another meeting. I'm sorry, Lordship.
There was no interim press for today, so
Yes, yes.
might as well
I'll
complete it. That will be listed after the vacation. That's very considerable.
Here, from the present incumbent, I have taken the information. But they have instructed me to take 3 weeks time. The matter is under consideration. But the date after.
Kindly a date may be fixed because it's the old order on the judge. 2023. Understood, my lord. After court may a date may be fixed. Right?
In the second week of May.
Hearing.
Objection.
11.
The affidavit has been filed. It's accordingly and one, and then it's either. Six. Yes. District Commissioner SDO. Chairman. 8, 9, and 10.
Registration.
Hmm.
Registration is in the page 22.
20.
Last.
20.
For non-proceeding.
Why did you not appear?
There are 2 dates, my daughter, that I have been stated, my daughter, in para 8, page 8.
What have you stated?
The 2 advocates, my daughter, Mr. S. M. Sharma has not, I'm unable to come last 6 months in person. And another advocate, J.C. Chaudhary, also aged about 85 years. 10 to 8 years.
Hey, you are the new counsel.
My lord.
The new counsel.
Yes.
What is the claim in the writ petition?
And that in the claim, it was under revision of pay scale, my lord. That's a retired person.
Yes. Any objection?
That was the claim has been from the government. Where I'm appearing on behalf of Corporation Department.
You are employed under what? Which department?
My lord, it is under the, my lord, sports and aviation under
Huh?
flying club under.
Flying clerk.
Flying club, my lord. It is under the society, but the functions, my
So
lord,
how are you entitled to revision of pay?
guided by the, my lord, Social Welfare Department.
Are you government servants?
My lord, as the government, my lord, provided salary.
Maybe, but you are not a government servant that you will be guided by the pay commission.
Then the petition is
Why should we restore a petition? If you can't satisfy us that you have a claim.
Actually, I understand, I have done not done for the entire
You have not done,
And
go through and come back. After we list this matter again. On 27th April. On my request, please very
on behalf of VN5.
and Mr.
KS. Let's get
A.S.
KS Ujjwal on behalf of Western.
Yes.
But I have received the instructions as regard the incumbent who was holding the post earlier and the present incumbent.
What is the status of the SLP?
For the SLP, it was filed on 12th of March 26, and it is pending, or it is not ordered in past.
Not even listed.
No, not listed. It was filed on 12th of March. And in Lordship's query as regard Mr. Santanu Bhutmare, kindly see page number 3. The first paragraph. He's not in office.
So what has happened to the orders passed by the court?
For the Lordship,
What steps have
what-
the succeeding officers taken, successor officer?
for the department has taken steps for filing an SLP. So,
Your file, it is lying defective perhaps for the past 1 month.
no, I have spoken, they are taking steps for listing of the SLP.
See, we are the executing court, we are concerned with compliance of the orders.
That's
We are not here to ensure that you go and file an SLP and get it listed, get an order.
no, that's
Right, so file an SLP so long there is an SLP, even if it is admitted, we may take judicial notice. If not, orders have been passed,
as of today, no.
nothing,
But
it's
but-
going to be 1 month.
it is an action on the part of the authority.
Your
They are-
action of the part of
they
the
are not-
authority will not accepted be a ground to disobey and deliberately violate your order.
What I am saying.
We want to know what the successor officer has done so far.
Logic and intended to the application has been
And
filed.
what is the status of the other gentleman who's gone on leave since September 24?
Yes, no, till
Has he debited office?
No,
Has
the-
superannuated?
no, he is not superannuated, but
Hmm.
till May 2026 was the information. Since 2nd of February 2024 and till 31st of May 2026. That means when the order was passed and the order of appellate order has come, it was not the order.
When was he on leave? September 24.
Lordship, can you take in the bunch third two? This is the information I have received. Since 2nd of February 2024 till 31st of May 2026. 14 days. First order was passed in June 2024 in the writ petition. And second in the appellate order was on 21st of August 2025. The IA has been filed to include the new incumbent, the present incumbent. Lordship, I kindly grant us some time, Lordship.
You give us a specific instruction what steps are the government taking. Otherwise, we are drawing up contempt proceedings. We are making it very, very clear.
Lordship, kindly allow us some.
We'll give you the absolutely, we are calling it the matter in 20 April. 20 April. We want instructions, what steps have you taken so far?
Can you first one more?
Right, 27. 27,
27.
be ready for with your instructions or we are contemplating to issue proceedings, law proceedings under the contempt of court side.
Try to get.
Judgment?
The judgment details regarding this blocking of the orders of the court, in the conviction of the.
Excellent.
So what I play subject to you, what you're not. Contempt. From the date of issuance of the notice, my lord, justice service was taken, we have filed affidavit. They have not filed affidavit in the matter. They have only brought some letters and before the court. We do not know what is going on.
The concerned officer is not in office, but that is
No,
my
he may not be. Whatever he has done, he must
The
show.
subsequent officer has taken.
My lord, your lordship, can you see Gauhati High Court
Prior-
contempt rules,
prior
rule
to,
7. Rule 7. May I just read?
but the information is
Yes.
prior to.
Rule 7 is whenever the High Court issues notice, it may, so to do, dispense with the personal attendance of the person charged with the contempt and permit him to appear by his leader and make discretion. So discretion is there, my lord, to that the personal appearance is dispensed of. But since your lordship, in this case, I will pray, my lord, that your lordship will not, that discretion will not apply, my lord. Let them appear before the court, particularly. They have not filed any affidavit, not filed any so-called reply, just bringing letters by letters, my lord. We don't even know after receipt of the notice. The Supreme Court has clarified, my lord, even the third party right, my lord, the person who was not parties to contempt, my lord, they are also liable for compliance. Their filing of the appeal or review does not dispense them with anything. As per the High Court rules, my lord, I pray, my lord, your lordship will not exercise ask them to appear before the court. Then thereafter, your lordship may that
We'll give them one last opportunity.
the
on
last
27.
option was given on the for the order to provide the compliance on. Lordship, there is an order for 27 to 26. Order provide with the complaint. No show for reply, nothing, my lord. They are just taking it to their own hand.
But
Mr.
one of the officer concerned who is the party here, he was not in the office, but my instructions there. And lordship may kindly grant us time till 27, but let me have. Because the officer was not there, or the petitioner stated that notice was served on him, but the record shows that he was not in the office. One time is in the personal capacity, but he is not aware of that. And filing of show cause not by the officer concerned.
When was the aware of this?
No, but
He is assuming office since March. This gentleman, when was he on leave? He's on leave. From 2nd of February 24.
24.
So when did the successor officer assume office?
The successor officer, he came, this present officer
He
came
assumed charge on 15 December
in December.
25.
Yes.
So from December to April, are you telling me that he was not aware?
Justice service, the petitioner has taken in the month of November 25. Lordship may kindly allow us on 27th, Lordship may kindly think of. So I'll come up. And
Heard Mr. B.D. Das.
the IA has been filed for implement of the present income.
Huh?
And I has been copy of the IA has been served on me yesterday to complete the present income.
Is it there? Not listed. The so it's a past year. So that's all. So it's all needs to be done. Structure. See, it shows the
Same person is one and two,
Respondent one and two.
same person.
Respondent one is also added in respondent two. Has been on leave as per official reports, effect from 2nd of February 2020. March 31st of May 2026. 2nd of February 2024. 31st of May 2026. Respondent submits that successor officer joined office on 15 December 25, but he was not immediately made aware of the past. Submits that ongoing SLB is so specific on the past thereof. Time. Raise the court on the next day fixed. And Mr. B. Das has pressed into service the judgment of the apex court in 2006 5 SCC. The action of respondent which is basis and therefore proceedings, appropriate proceedings be drawn up. Submissions of the respective councils have been taken. Last chance. Status. Rise the court with regard to the compliance of the directions contained in the order dated past in so and so, which to be affirmed by order dated so and so past in the April number so and so. 7 clear that is the instructions as directed to be placed below the past consequential notice, appropriate consequential notice, placed on 27th of April.
Para 21. Liability of the third person. That be of the matter, my lord. So not to redirect the present incumbent also to file.
Which judgment you are referring to?
Israr Ahmed, my lord, 2026 SCC online. Para 20. Appeal has been given regarding the liability of the third person. This view of the matter, I pay my lord that present incumbent may also file with.
Twenty-seven.
I am raising a preliminary objection as to the maintainability of the
Filed the affidavit on the last visit and you also served the copy to the respondent. But the affidavit has not been recorded yet.
Affidavit not on record.
Yes, your lord. You have filed it on 9/3/2026.
What affidavit?
That is
My lord, I have filed an affidavit raising my preliminary objection, and then against that affidavit they filed a
Can it be on record?
Not.
The
My lord, one, two.
One, two, there's two and three only. In three, raising preliminary. There are these three definitely. It's the matter.
One, two, three.
Respective counsel. Yes.
Last location, it was reserved for order.
Reserved for orders.
Herein the issue is that your lordship, the candidature of the petitioner was the ground of station trademark.
Yes, yes, yes.
But
We had come back to page number 53.
yes, 53.
53 is an opinion of the dermatologist.
Your lordship, kindly see the documents, your lordship, from their side, your lordship.
We are going
My
by
case is that
your petition.
yes. My case,
Hesitation mark is to be determined by a psychiatrist,
yes, yes.
not by the dermatologist.
My case is that, your lordship, the review medical examination, the petitioner was brought by the CRPF, your lordship, before the Gauhati Medical College. And on preliminary inquiry, the doctor has given opinion that the petitioner has no abnormal.
Where is that?
But I have made a statement, your lordship, in my petition. And the doctor also advised them to,
Where is that opinion?
that opinion, your lordship, is from there.
I have not filed
We
any
had
affidavit. also.
listed it for the simple reason because submitted before the court that it is a covered matter by placing a judgment order passed by this court. When we examined, we found that that order was disposed of on the ground that there was an opinion by a psychiatrist saying that person is normal. There is no abnormality. Here the opinion is of a dermatologist. Page 53.
Yes, yes.
So
medical-
how it can be similar?
Medical documents, your lordship,
No, no,
get
no.
from,
Mr.
I
Counsel,
understand, your lordship.
no, medical document doesn't mean that you get it from any doctor, any opinion. We are on the ground that the authorities are concerned about the mental health of the candidate as to why there are hesitation marks. That opinion can only be given by a psychiatrist.
Yes.
You are getting an opinion by a dermatologist saying that there is no active skin disease.
Yes.
Hesitation mark is not a skin disease.
I admit, your lordship, that. But my case is that, your lordship, I was examined by the psychiatric department.
We don't know. So therefore,
But
we have
that
got it listed.
document is not with us, your lordship.
Therefore, it was
That document is
therefore it
available
was
with
not
them, your
proper
lordship.
for you to submit that this matter is covered by placing an order when you know that it is not similar. You are dismissing your petition on that
Lordship,
ground only.
Lordship, kindly please, your lordship. We
We
have
rely on
opinion.
the submissions made by the council. When you say it is covered, take it, yes, it is covered. Subsequently, we find that the order you are relying on was an order passed on the report of the psychiatrist saying that there is no mental ailment. You are now relying on an opinion by a dermatologist to say there is no skin disease. Is hesitation mark a skin disease? Can
Once,
it be certified by a dermatologist?
once he was examined by the psychiatrist.
We don't know that,
therefore-
but we don't know that, Mr. Counsel. If you want to see the recording, we can show it to you. Your submission is the covered matter, and you are given a order of this court disposing of a similar matter.
Covered matter, your lordship, only because of that the ground on
If you project before the court that you have not understood what the court has indicated, very well, record your submission,
My-
dismiss your petition.
But my case is that, Your Lordship, I was not even properly examined by them.
We'll
Your
hear you, we'll hear you again. Please, this matter on,
But from there,
on 30 April for admission hearing. This matter was listed earlier on, was, was heard on 31st. 31. 31. And the matter was reserved for orders. Stop. The counsel for the petitioner has placed the copy of the order passed by this court, by the order dated so and so, passed in WPC so and so, and made his submissions that this is a covered matter and can be disposed of in similar lines. So, the order passed by this court in WPC number so and so, by the order dated so and so, was a matter where the had disposed of the petition, directing the respondent authorities to reconsider the case of the petitioner by the review medical board by a civilian hospital, where the psychiatrist had given a opinion that the petitioner in that case, petitioner of that petition suffer from any mental illness. Petitioner in WPC so and so case was rejected by the respondent authority on the ground of presence of stage karma. Circumstance. Medical, what do you think? Board. Medical board. Evaluation by considering facts of the present case. After revival of the pleadings available in the court, seen that the case of the petitioners was rejected by the responding authority because citation cut marks. So, according to the petition, this case, the facts of this case is similar to facts in WPC so and so, which came to be disposed of by order dated so and so, and therefore this writ petition may also be closed in terms of during the process of seen that at annexure 4, page number 53, petition opinion rendered by the OPD, wherein the registrar, the Department of Dermatology and STD, had given a finding that the patient, namely the petitioner, does not have any active skin disease at present, and the patient is fit from the dermatology side. Yeah. This opinion of the OPD department of the DMC, in respect of dermatology, so the petitioner's candidature was not rejected on the ground of a petitioner suffering from any skin disease or STD. Rather, his case was rejected ground presence of hesitation cut marks on the left forearm. So, whether these are hesitation cut marks and the petitioner suffers from any mental ailment and or having suicidal tendencies, will have to be properly diagnosed by a competent medical practitioner. So, dermatology department does not reflect the absence of any indentation cut marks, nor any opinion has been rendered that the patient is mentally sound and stable and capable of being inducted in services in the services of a disciplined force. So, that medical document and goes to the writ petition at annexure 4, page 53 cannot be a document that Department of Dermatology, PD department, cannot taken basis to determine the claim of the petition that suffers from any mental illness. The absence of identification factors. Attempt made by the council have this matter disposed of has been similarly situated in terms of the facts and circumstances as in WPC number so and so, and have the matter disposed of similar lines in terms of the order dated so and so. It appears to the court to be an attempt purposefully done. Such practice is seriously deprecated by the court. Expected by the court that such practice not be resorted to in future by the council. Since the council considers, since this matter was not disposed of in terms of the submissions made and be covered by order dated so and so, passed and so, is this matter for admission hearing?
Not have any intention. I made solution only because of that. That matter also you have the same abnormalities was there.
But we have expressed whatever we
my
have
case is
expressed.
that
Your
what I'm
intentions,
saying, Your Honor.
Mr. Counsel, you see, it is not for nothing that we address counsels, learned counsels, right? You are expected to be learned and apprise the court. If you are saying that these matters are similar only on the ground of medical opinion, how can we accept this coming from a learned counsel? When you know that the opinions of this matter and the other matter are completely different.
For the record, Your Lordship, from the record, Your Lordship.
We'll examine it, but you did not insist on calling for the records. You said this matter was covered and is to be disposed of. We had accepted your submission coming from the bench, coming from the bar.
I'm explaining this.
Your apology is accepted, but don't do it in future. Next on 30.
Kindly provide the measures for timely.
What? That circular.
Circular.
We'll have to,
Yes, Lordship, otherwise,
why do you want a pass over?
SS Roy on the council is makes in another court. That's it. That's right. Otherwise, that notification is still pending. Lordship.
Right.
Yes,
Therefore, we fixed it. What is there? Is there anything more to be submitted?
No, Lordship.
The record is present.
Within one
Master
180
case and the instruction.
yes, Lordship. 180 days keeping.
Which matter is he appearing?
All the,
In all the matters.
in item number 23.
22, 23 and 20. 22, 23.
And earlier circular was 17.
Yes.
17,
Yes,
that has
180 days,
that has been sustained.
yes.
All petitioners,
No, some petitioners are not following this, under this. OBC certificate is see on 180 days will be covered.
yes, Mr. Roy. The earlier circular sustained, isn't it? There any difference in any of the matters? Actually,
Actually, Lordship, not, all of them will not get, right? Because, kindly see there, my lord can take
In item number 20.
180 days.
180 days. Then it is this. Why the least expect to provide it? Today,
provided 2 p.m.
Have some difficult time to function in a perfect manner, Lordship. Let it be. I will give my
Your friend is in.
Lordship.
You share the list, and if there is a consensus, we close this matter.
Lordship.
Get me.
Prayer. Lordship, we recently filed a similar writ petition pertaining to the petition. Lordship, this matter may be taken along with that.
What has happened to the writ petition?
Lordship, number is 966.
No, what is the status?
Lordship, actually, the present petition that has come to me pertains to deprivation of pension.
What is the status of that other writ petition that you filed?
Lordship, actually, it has been filed, it has come for motion. It has been issued and it has been listed after 4 weeks. Lordship.
4 weeks.
Yes, Lordship.
4 weeks. Right. It is submitted that the present petitioner will file another writ petition saying WPC
966.
966/2026. Submitted the file that both need together. According to the petition listed along with 966 of 2026. Mr. S.P. Das for
Number 3 and 6, my lord.
BNC.
Yes, my lord.
BNC. And
Nine
Mr.
for that.
Chakraborty for? Huh?
1, 2, and 5.
1, 2, and 5. Mr. R.K. Talukar for 4. Finance? 7. Fine.
My lord, department, section number 3, passed a order, passed to the order dated 9/2/2006. And after hearing, they are ready to dispose of the matter. Subject to verification regarding the marital status of the petitioner is the mother, unmarried daughter of the first wife, and first wife got divorced, and thereafter under the employee got second marriage and second wife receiving the entire pension. Now this pensioner for year of pension. And according to passed an order on 9/2000, and that was to be disposed of by the government, and accordingly on this 7/2020, exhibit is X. Kindly have a look.
So they have agreed,
Yeah.
subject to verification.
Subject to it. Otherwise, the matter is disposed of.
Yes, Mr.
The third part in regarding paragraph 9, 10 maybe seen my lord, it was compromised by the petitioner in a succession case. my lord. So far the amount is concerned. Receipt of lakhs, my lord, it was compromised. I think
That is
the
my
retirement dues. And so far pension is concerned, my lord, I have got a son. The hearing I placed, my lord, I have got a son.
Who are you? Second wife.
Second wife, my lord, after divorce of the first wife, my lord, I got married.
After divorce, he got married.
Yes.
Then the husband
He died, my lord. He
in
died
harness.
living, yes, died in harness, leaving one daughter. Daughter is the petitioner actually, claiming share in the pension, my lord. Now, our stand is that she got married, my lord. That is share in
without
the-
I have filed that.
So
Still,
far,
How are you
still-
dependent on your father? When were you staying?
Sir, I am still with my mother
Then how are you dependent on your father?
because there is no source of income. Mother also not source of
No,
mother
no,
also
after the death of your father got a pension.
no. Mother may not divorce and without electing. Divorce pension that will also enclosed.
She was not receiving pension.
No,
Then how are you claiming?
I am killing pension from my deceased father
How?
because I am also entitled to that. I am also that I am unmarried legitimate child.
Unmarried.
Yes. And I filed my lord reply and saying that reply saying that still I am unmarried.
Where is the provision of the
Says that unmarried daughter also entitled to that pension, and accordingly, my lord,
unmarried dependent daughter?
unworship.
But you were staying with your mother.
But mother also, my lord, having no source of income because she not,
But
no,
you
no
have
any aluminum was allowed.
But you are dependent. Where is the provision of the rules?
My lord, the order dated 9/2/2020. Here it is mentioned. Order passed by the body bench 9/2000. Regarding the scheme of compensation family pension,
Where is that scheme? You want to see that scheme? Where is it?
scheme of compensation appointment.
You don't have it with you. Have it with you.
And another, my lord, that is also enclosed, the order. My lord, better, my lord, this X, exhibit X, kindly. That is already. They are not denying, department not denying, just subject to verification of my marital status. Otherwise,
How will they verify? How will they verify your
let,
marital
let,
status?
let them exercise
How?
to verify.
So why did you come to the court? Who invited you?
My lord, regarding the pensionary benefit,
Right, so
whether I'm
we'll have to decide it.
and so far notification I have also enclosed that is
Once you have
9
come to
August
the,
2018.
once you have come to the court, allow us to decide it.
My lord, that is also enclosed, my lord.
Unless you want to withdraw the petition and approach the authority, you can't stop me from doing that.
No, subject to, my lord, so far this order,
We are not passing an order on the
7th
basis of this.
March 2026.
We are not passing an
order passed.
we are not passing a petition directing authorities to decide. We will not do that. in view of this decision by the authority, they did not want to go and approach the authority. He can't
Yeah.
stop you.
Therefore, my lord, this honorable court passed order 9/9/2023, filed a representation, and after receiving the representation and with hearing of both party, this order passed.
What are we to do now?
Now this order passed, so my lord, this decision continue.
Huh?
So this matter will dispose of subject to this verification. Subject to
What
verification,
dispose
and
of?
department will pass the order.
Department will pass, you go and approach the department.
Therefore, my lord, this order already submitted before this order. That is X.
We have seen that. You have come before the court. What?
According
Department has passed an order saying that we'll examine it. Go and approach.
so far, the order dated 9/2026
Heard
by this order.
Mr. Counsel for the
And
parties.
in compliance of this order, this order passed by the
petitioner claims to be the unmarried daughter of Kate so and so. Family pension. Married daughter of Kate Konok Pathok. Kate Pathok.
under number 3.
Under the respondent number 3.
Four, my lord.
Serving as a constable. Sir. Serving as a constable of the first Assam Special Reserve Force under respondent 4. Subsequently, the father of the respondent died in harness. So, the petitioner, father of the petitioner is to be the daughter, marriage, Das, and Bharati Dekar.
Konok Pathok.
Konok Pathok and Bharati Dekar was the first one. So, maintenance, etc. were filed. Subsequently, divorce proceeding was filed between Konok Pathok and Bharati Dekar. There was a divorce granted.
Divorce meant earlier, prior to second marriage. That is divorce judgment 28/1/2011.
Private respondent claims to be wife of dead and after tendency of the court, tendency of the proceedings. The order dated 7th of March 2026.
Hearing both the parties.
This order there are from a perusal of these orders that subject to verification. Circumstances cited in the proceeding, the petitioner is permitted. Claim order as to post in the I is also dismissed. And as there's more of all.
No I is there. I is also.
That's a standard order. As per rules.
Time.
The claims of the parties be decided by the respondent. Yes.
My lord, in item number 36, my lord, we are praying for some time to file a reply to the affidavit filed by the respondent number 2. So they have not filed any affidavit in our case, but they have filed an affidavit in item number 34, and perhaps they are relying in.
Same.
You're relying.
Lord,
Then you have to serve them a copy.
Already
Yes,
served.
we have received it, but I need some time to.
Yes. Mr.
Subject to your lordship's convenience. Can it be on 7th
Seventh of
May? Although 5th is also a, well, immediately after the vacation, you also. Can it be 7th, subject to your lordship's convenience?
there are 27 matters already picked. 7. Still have it, or we can have it on 14th.
Possible, let it come up with a fixed time.
Of course, it has to come out, we are fixing a date. It will be listed as a fixed date. Mr. S. Chakraborty appearing in WPC number
617.
617 submits that the respondent has filed an affidavit WPC 870
870.
87026 and I say in affidavit of the other matters. Therefore, it is liberty to file a rejoinder. The affidavit filed. There may
WP 870.
870 and the review petition also.
Yes.
7 is agreed. You are hearing here.
Please, my lord. My lords, I appear on behalf of the petitioner. Am I audible, my lord?
Sir, Nath, you are appearing for respondents.
For the respondent, one sole respondent is there.
I will be issuing notice today.
Lord,
Right, counsel.
I need some time to
Notice.
have my instruction.
My
need
lords,
some
may I
time to
just
have my
point
instruction.
out,
Otherwise, I am told that some steps have been taken from their side. Let me have the instruction.
my lords, may I just point out only one page, my lords? Into my notice of arbitration issued on 12th of February, my lords, they responded at page 695. My lords will just have page 697. And on 697, it is quite
We are
clear from
issuing
the
notice
respondent.
today. Let them respond.
Yes, my lords, I understand.
Yeah.
My lords, may I just point out only the last line of page 697, my lords? They sought further time to appoint, my lords, but however, in accordance with Datar switch clear, they no longer have that right since 30 days has expired.
Yes, tell us.
Because at
Page
page
number?
697, page 695 is their reply to my invocation of arbitration. I am reading, my lords, at page 697. The last few paragraphs, my lords. It is clear from the respondent's reply that there is no dispute on the arbitration clause. In fact, they have said that they have started the process of appointment, but that appointment requires 21 days more, finishing on 2nd of April. My lords, today we are on the 7th of April. We are now almost 1.5 months past their right. Therefore, my lords,
Therefore, we are
respectfully
issuing
in light of,
notice. Let them respond what they want to do.
I was only pointing out, my lords will have to appoint. That I understand.
Yes. Yes, where is the date? Date on the right hand side?
Yes, so date of NCL certificate.
Date of certificate.
Yes.
Certificate. 5 time limit. Right. This is the whereby the candidates were permitted
certificate was valid for only 1 year.
we read
Yes.
read clause 3(1), effect from so and so date.
Per clause 6.6 should be NCN, and NCN certificates are valid for only for 1 year. And now, per instruction received from respondent to
Same ground. That's the only matters. Timeline.
HCL 7/1/2000.
Why was it rejected?
Last cut off date. Identify.
Same date, but it is last date.
10, 40, 10.
9/5/2000.
can go.
It's inside.
Item 22. Same advertisement.
Same.
First, 31. January 25, 31. February 25, March 25, 31.
9th May.
Yes.
When was it applied for?
1 year from the date of issue. So
This was not produced.
this was not produced. Not
Not
produced.
because it
Not
lost
produced.
its force on 2020.
Prior to 3 years,
Prior to 3 years, but at the time of document verification, it is not produced document and they
produced.
also not valid document.
When is the notification?
130,
70 days. 1?
131.
Six point six says about NCL.
How do you get the benefit? Advertisement talks about NC.
But it is valid for only 1 year. Then therefore, it cannot be accepted. At that time, 2017 NCL certificate was not. That time, NCL not required. Therefore, that is not.
Understand the validity. When did you attempt to put it? Not at all. Fine. Fine.
But was issued on 2017.
Say you
Then
read
only
close what?
6.6.
Clause 1. 3-1.
3-1.
Take from 23-1-2017, the date of the commission did not register
years before the last date of receipt of application and up to 180 days. On follow years before the last date of receipt can follow up to 1.
Instruction say
Of 6.6 says about NCL certificate. Earlier opinions that clause is not there. About the NCL certificate, and NCL certificate valid only for 1 year. But other cases, NCL that is valid, therefore that can be accepted. But here validity is already.
5 and 6.
About the or until not different. Or it says that
6.6
verify.
6.6 is mentioned.
Yes, 6.6 mentioned, but in our instruction is directed to further directed the CRPF to examine the instant cases if face keeping the above facts and take necessary action accordingly. That instruction, Lordship, it should be in keeping on mind that 6.6 plus 6.6. The OBC certificate should be in
6.6 irrelevant. Right. 6.5 is the basic certificate,
yes, sir.
and 6.6 is the certificate that crucial date. That crucial date will have to be read in the
One thing is also there, Lordship, and last point. It is categorically stated that Commission shall not open cases where the final result has already been declared before 23/1/2007. Only, yes, Lordship, only in these cases, the Staff Selection Commission directed the concerned tabs to verify and on mind about the and pass the appropriate.
now meetings. Right. Second petition. Second petition.
Second thing.
Certificate itself shows the bill. I will not applicable. certificate has to be.
Carrying that.
Then 5.
Right.
12/9/22 order. Dealing for 1 year.
1 year.
When was it submitted?
The time of document.
That is totally. Which are the petitioner?
Prior to that one. Last column is the recommendation.
One, four, and five.
Yes.
Here NC is that.
One eighty days. Of the same.
When was the document verification? 7th.
Number 133 also.
Seven.
11. Seven, 25. Number 4. Six. One. And just before that, my lord, 138 is 138. First was Sohan, my lord, 8, 11, 2025. And certificates. Come to 7, 25. Second column, second part.
Number 5, 26/11/2024. And then number 6 is 125, 24/7/2024. Counted for one, just use the proceeding book. Subject to correction is 340. Correct. 1 day, 10/9/5.
Their own certificate.
3 persons are eligible. As per petitioner, 3 petitioners are eligible. Petitioner number 1, 4, and 5.
Same certificate. Valid for 1 year.
Twenty-six, 12, 20. But,
You have to start.
yes, Lordship.
Okay, you
But-
see, valid for 1.
we are as
That
closing date.
crucial date,
Yes.
then it has to be given. Certificate. Crucial date,
14, 10, 20.
right?
At that time,
It
this
was not
certificate
there.
is not there. Therefore, we are
But prior to that, the date of verification,
not there, but they not produced. No, perhaps that instruction not received. I think that crucial date is counted by the
crucial date, cut-off date,
yes,
last date,
14, 10.
14 10.
Yes.
Now,
And-
in terms of
circular is on 17. I have no idea. I
Why do you say 3% are?
one
One was 1410. Can certificate were issued on 7.
Item 28.
non. Second is also the same. Third, toddler and regular charge of the sector paid to supervise was assured study and payment of wages of CPA. The entire process of recruitment and employment paid. After the complaint was transmitted back to the some information back to the comment department. Judge himself in fake mustering of above CPA, which is correct. Now, the above while there hence it is there are by his above act, said R.N. Chaudhary has failed to make manner which is not supported by a resource document. How much is that? Per week. 44 plain reading of the charges, I do not find that these charges are vague. These are very clear charges. And in that respect, Lordship, what would be a vague charge that has been dealt with by the Honorable Supreme Court in 2036 SCC 915? Thirteen 515. Have not for more than inquiry on these charges. Has the same not be sufficient for demonstrate for the unaware of the fact of what kind of defense he should put for rebuttal and the all charges now. Not not before are found because of the sort of all of that and the allegation not so how how we have the charges inquiry how some of the charges against him. to know. Can go right to what is the it looks the existing. Therefore, now that charges are there, cannot be compromised. Now, in so far as worship the action of the petitioner are concerned, I would reiterate the petitioners have approached this court. Have a reply also. After having a reply, now they want to put a stop. He has already participated in the inquiry, he has submitted himself to the inquiry. So far as worship petition of my friend challenging the charge is concerned, I may take your lordship for the honor. First, I take your lordship 1987 to SCP 179. It is that is at least. High Court was not justified in questioning the show cause. By showing cause, and the court should be reluctant to interfere with the notice at that stage, unless the notice is shown to have been issued palpably or the purpose of issuing show cause is not always show open for the and the court before that would be premature. The High Court, in our opinion, was not to have interfered with the show cause. I've already found a response. Next case on the same issue. What it would be. 2006. 28. Union of India versus by a series of decisions of this court have ordinarily no writ lie charge sheet or show cause notice by executive replacement. This was a case of. There are a few citations here. Next. The reason why ordinarily a writ petition should not be entertained against the mere show cause notice or charge sheet is that at that stage, the writ petition may be held to be premature. The mere charge sheet or show cause notice does not give rise to any cause of action because it does not amount to an adverse order which affects the rights of any party unless the same has been issued by a person having no connection to for the allegation in that case. It's quite possible that after considering the reply to the show cause notice or after holding an inquiry, the authority concerned may drop the proceeding and hold that the charges are not established. Well settled that the writ lies when some right of any party is infringed. A mere show cause notice or a charge sheet does not infringe the right of anyone. It is only when a final order imposing some punishment or otherwise adversely affecting a party is passed that a said party can be said to have any grievance. Which jurisdiction is discretionary, jurisdiction and heavy. Such discretion under Article 226 should ordinarily not be exercised by quashing a show cause notice on a charge. Five. The same and five. Six. Paragraph 13. First, all the issue can be summarized to the effect that charge sheet cannot generally be a subject matter of challenge and it does not adversely affect the right of the delinquent unless it establishes that the same has been issued by an authority not competently initiated either the disciplinary proceedings or the charge sheet can be closed at an initial stage as it would be a preliminary stage. Are not liable to national account have been initiated at a related stage not be concluded in a reasonable period unless the delay creates prejudice to the employee. Gravity of alleged misconduct is a relevant factor. So, okay, all the material on which and the documents on which the state wishes to rely on. My humble submission was no ending. Now, hey, there was a there was a court of inquiry, that's all right. But the court of inquiry, this is not the court of inquiry, I cannot punish you. Basis on which I would proceed against the employee is the criteria which reduce the charge payment. I cannot go beyond. My humble charge has been very clear. Now it is too late in the day for him to turn around and come and say, charges. What? I will reply, and as it is on a plain reading of the charge memo. Therefore, in my humble
desired a compilation. The state compilation, I have added judgment of Supreme Court. Alia may not permit. I just hand over the compilation, and afterwards, I respectfully point what learned is submitted. for It's already given, my lord. My lord desired a compilation, I made a compilation.
Then again, I will have to.
I am submitting copy. This is already submitted. Already submitted. Already all the judgments are there. I'll read from the judgments already submitted. Nothing new, but the lord desired a symmetrical way to be presented. I just do not want to bother my lord. My lord, please next part.
You know, mechanic right. Design.
It is my duty, my lord. Some of the submission of learning, he has raised the point about the vagueness, definition of the vagueness charges. Now, whether one can, the charge official have got it right, approach the court of law after replying the charges, are stated that the charge official, Ramnaran Joshi, was the receipt of, was the disbursement. Then it was stated that there is enough sufficient evidence, the memorandum of charges, which, so literally speaking, charges does not suffer. Then he also stated that a court of inquiry, is the basis, but ultimately it will be decided on term of charge. It's replied vis-a-vis further. But that is why these stations I have submitted for judgments and judgments today. I'll read after submitting a lot to the paras of RN Choudhury case, that is 38, item number 38, my lord. But why am I agree? Because of the memorandum of charges, it is never vagueness. The vagueness is supported whether it's uncertain, whether it is lacking basic material, whether it is a case of no evidence, whether it is a case of there is an arbitrariness, whether there is a malafide, whether there is any unreasonable action. And at first I answer the genesis as learned is taken. That court of inquiry is nothing, but I have already submitted on the Sanjay Jeti and this Honorable High Court order of Notice for that was the further action in view of the VCT court of it. So I will not deliberate upon the court of it, but I will read here, my lord, item number 37, Ranbir Kumar, and subsequently also counter affidavit, my lord, they have stated that the further action has been so based on the recommendation of the court of inquiry, by humble submission, the court of inquiry is initiated because it is the mandate of one. If someone is to the court of inquiry, the mandates of Rule 180 has to be followed. It has not been followed in the instant matter. And in the reference, I have mentioned the Sanjay Jeti's case and this honorable court order, Notice to Notice. So, my lord, so the charge arises. Preliminary inquiry. This is a court of inquiry. I was not present. I have not examined the witnesses. That is my lord violation of 180, Article 1. Second point, my lord, I have finished up with their recommendation how the charge originated. Now I come to the charge sheet, my lord, if my lord permit. My lord, this I my lord, just one paragraph. Why the it is not only the vagueness of the charge, it is the other parameters, essentials of the charges. Yes, my lord. I come to that question of law. That, my lord, that is my last subject. Yes, my lord. Yes, I cite the judgment, my lord. My lord has not been empowered under Article 142. My lord has been empowered by Article 2 to sue, 2 to seek. My lord may not be the appellate authority of the disciplined authority, but my lord is the appellate of the authority of the decision-making process. Decision whether legality is there or not. I am not on the inquiry, my lord. I will cite 3 judgments. I have already 2 paragraphs where my lord is crystal. I just from the same Chaudhary scheme, I draw my lord's attention to case 10. No, my lord, this is what Lane DAG has read, item number 38, my lord. Case number 10. Petition number 19 of the 25. 10. So, landed DAG has already defined the vagueness. But I am on the vitiation of the charges because not only for the vagueness, but for the malafide, lack of basic material, lack of evidence, and uncertainty. How I did it? No specific violation of any established policy, guidelines, procedure has been mentioned in the memorandum of charge. 2, my lord, memorandum of charges in the matter of allegation that the procedure was adopted contrary to act or regulation is misleading. No definite act has been quoted by. May I kindly draw para 12 Roman 1, my lord. How it is vitiated, my lord? No specific violation of any established policy guidelines procedure has been mentioned. Second, my lord, the memorandum of charges in the matter of allegation that the procedure was adopted was contrary to acts and regulation is stating no definite act has been quoted, my lord. Third, memorandum of charges suffer from the non-gender of the following key witnesses, my lord, that thereby violating the fundamental right of the petitioner to examine and cross-examine them along with the procedural part of examination process. Yes, my lord. Now I come to the as my lord. These are the my lord will subsequently see. No, my lord. My lord, I'll now the citation of the. I cannot further defend myself. If there is a lack of witness, whom I should examine and cross-examine. If there is no document, which documents I should produce before the inquiry officer. Now I come to the judgment part. I have submitted the submitted that, but not here the I did submit policy data. My learned page has stated that the petitioner is the of oh my lord, 508 policy letter. My lord may at point of time may have a look on this issue. It is in that policy letter. This categorically stated. This is page number, my lord. That is page number, my lord. I'll just page number 57, my lord. Annexion 8. This is the point. So this is the policy letter, my lord. This policy letter says at the in the if my lord have just one point I will highlight, not other point. 58 pages. How I am not involved in the recruitment, how only I am involved in the deployment. Well, not para 4. Medical examination. The medical examination of the CPS should be carried out as mentioned as per the following paragraph. They should not will done the medical examination. Doctor. Next, my lord, just one line I read only, not taken much time from the law. My lord, as my learned age has stated, that the key is the recruiting office, which I make. That's why I have now, my lord. Now, my lord, I'll read the relevant paragraph of the Supreme Court judgment. See judgments already I have submitted. My lord, I draw my lord's attention. Page 14. Yes. One you submitted now. Earlier also submitted. I just for the sake of brevity, I have. But in the compilation, page 40. 1. State of Punjab versus VK Kanda decided. The issue was that, briefly speaking, was that VK Kanda memorandum of charges against another brother IS officer just before the change of the government for disproportionate property and allocation of land, Punjab. So when the government changed, they charged VK Kanda for his speedy action. My lord, I draw my lord page 14, para 12, and it will be crystal clear, my lord, from the judgment. Para 12, my lord. Para 12 is there, I think, my lord. Charge sheet. Because, my lord, what happened? VK Khanna, who was charged with the successive government, first came to the tribunal. Then tribunal,
quoting the Union in the Ashok Kakkar's case, which learned AAG quoted in the last submission, the Ashok Kakkar case of 1988, which says that one must come to the court after the inquiry, not before that. I have come before my lord before the inquiry proceeding. So I am on that line of argument on the, I read, my lord, if my lord permit. Charge sheet, however, stands challenged before the Central Administrative Tribunal, Chandigarh bench. Sri V.K. Khanna, the former Chief Secretary to the Punjab government, since 2796, and 2796, former Chief Secretary to the Punjab government, since 2796, and continues to be so under the government headed by Mr. Rajendra Kaur, but as the Chief Minister. The tribunal, however, answered the issue against the Khanna upon due reliance on the decision of the court in the Union of India versus Ashok Kakkar. Ashok Kakkar says, come after the inquiry, not before that. But wherein this court in para 4 of the report was pleased to observe, admittedly the respondent has not yet submitted his reply to the charge sheet, and the respondent rushed to the Central Administrative Tribunal merely on the information that a charge sheet to the effect was to be issued him. My lord, then this para 13 says, my lord, the subsequent reading may not be so important. It is on the basis of the above observation, the tribunal came to the finding that Sri Khanna will have full opportunity to reply to the charge sheet, as learned is stated, and all points are available to be agitated before the inquiry officer. It is not the stage at which the tribunal would like to squash the charge sheet as it stands against him, and the appropriate course of him would be to file reply to the charge sheet, invite the decision of the disciplinary authority thereon. The tribunal also recorded that during the course of hearing before the tribunal, it has been made known by both the parties that the inquiry officer has already been appointed by the state of Punjab, and he happened to be the retired honorable judge of the High Court. And it is on this perspective, the apprehension of the applicant, Sri Khanna, should be allayed and resultantly the tribunal dismissed. Which reference to Kakkar. And tribunal viewed, okay, you appear before the inquiry. Yeah, and way so and so of the matter. The matter was therefore thereafter taken to the High Court. Subsequently, I did. And the High Court recorded the court controversy in the matter to be as given. The Supreme Court of them. It is the action of the respondent in issuing the charge sheet, the petitioner, like using a hammer to swat a fly on his forehead. Are the respondents merely talking about principle, but actually acting on interest? The High Court came to a definite conclusion about high-handed, arbitrary, and modified approach towards Khanna. And my lord, this in para 14. This is para 14, Sri Khanna being respondent number 1, and answered both the issues as raised in the affirmative, and thus resulted in the appeal before the court by the grant court before the grant. So, in order of India, my lord, state of Punjab came challenging the High Court order, because High Court was the tribunal order, and after they say the charge wrong. It is not necessary to participate in it. Well, this and then in that the para 33, now I draw my lord's attention to para 33 of the order. Very important. Para 33, my lord, of the same compilation, of the same order, my lord. While it is true that justifiability of the charges at the stage of finishing a disciplinary proceeding cannot possibly be dealt with by any court pending inquiry, but it is equally well settled that in the event there is an element of malice or malafide motive involved in the matter of issue of a charge sheet, or the authority concerned is so biased that the inquiry would be a mere farcical show. And the conclusion are well known, then, and that even law courts are otherwise justified in interfering at the earlier stage so as to avoid the harassment and humiliation of public officials. It is not a question of shielding any misdeed that the court would be anxious to do. It is the due process of law
which should permit the society, and in the event of there being any affection of such process of law, the law courts ought to rise up to the occasion, and the High Court in the contextual fact has dealt with the issue on that score. On that basis of the finding, no exception can be taken, and that has been the precise reason as to why the court gave the so great in detail so as to examine the judicial propriety at the stage of proceeding. It's very important, my lord. And finally, my lord, in para 38, the appeal was in favor of D.K. Khanna. And I read, my lord, 38, on a perusal of the matter and the records in the entirety, we cannot but lend concurrence to the finding and observation of the High Court. The judgment of the appeals cannot be faulted in any way whatsoever, and in what the matter then the appeal failed, and we are dismissed without however any cause. Now, my lord, another judgment, another judgment, my lord, that suffices. That judgment earlier I just read, with my lord's permission, I read the paragraph. The judgment of the Supreme Court, I have that is 1986. It is not in the compilation. Earlier I have submitted. Today I can submit. I can submit. I can submit the relevant para, my lord. I can judgment I am giving right now, my lord. But I will just break to hand over the judgment. Can
Please to give us the text judgment that you.
yes, my lord.
Because
I break my lord.
otherwise we'll be pouring into the chart.
One of the I just flagged the deleted. Which is all in my petition and the rejoinder. And earlier, the note I submitted, there I have I just read the para 14 of the same. Quite apart from the fact that it appears to us, that the charges were vague and it was difficult to meet the charges fairly by the accused. Evidence adduced was perfunctory and did not at all bring home the guilt of the accused. Then, my lord, in paragraph 15, it says, Chief B.D. Sharma, learned advocate for the respondent, contended that no allegation had been made before the inquiry officer or before the High Court. I repeat, my lord, the vitiation issue was not recorded before the inquiry officer. Then what it said, the Honorable Supreme Court said, that the charges were vague. In fact, the appellant had participated in the inquiry. That does not by itself exonerate the department to bring home the charge. But this point is very vital in my submission. Reason behind is that it is similar to the line of argument what Lane just submitted. Yes, they can participate in an inquiry and they can raise the issue of vitiation of charges. The Supreme Court says whether they participate or don't participate, even after participation, they come challenge the charge sheet for its vitiation, for its defect, uncertainty, uncalled for weaknesses. But then para 17, that para 17, para 17 is very important, my lord. The para 17 says, my lord, the application of gross principle of natural justice must always be in conformity with the scheme of the Act, and the subject matter of the case is not possible to lay down any rigid as to the which principle of natural justice is to be applied. There is no such thing as technical natural justice. The respondents, the requirement of natural justice depend upon the facts and circumstances of the case. But what I'll finish saying, my lord, that my humble submission that my lord is there. My lord is maybe this learned age submitted that my lord cannot be the appellate authority of the decision. Yes, earlier occasion, not this occasion, but it is the common saying. But yes, when the writ has found that the due process of law has not been followed, is empowered to delve upon the to exercise the judicial power. My lord, they have the authority, the more the responsibility. They have the authority. They should exercise their power more objectively. Malafide is a synonymous with the arbitrariness, and arbitrariness is synonymous with the unreasonable. And my lord, this I have added one BC Chaturvedi's judgment in this order, wherein the Supreme Court has stated that everybody cannot come to the Supreme Court for exercising Article 142, and that's why High Court is well justified enough to look into the grievance of the petitioner. If it is definitely, it should be legal. Because, my lord, yes, my lord, can it? Yes, but the BC Chaturvedi has pointed out, but that part is good. Yes, I learned from it. But the deed power when there is a violation, that's injustice, my lord. When there is an arbitrariness, when there is a malafide, when this mere suspicion cannot be a substitute of legal. That is my humble submission. And there is a, my lord, in this the item number 38, there is an inordinate delay. My lord asked for the CBC guideline. That inordinate delay part annexed the along with the writ petition. I have submitted with my compilation also, which is CBC guideline. That that is in the page number 55 of writ petition number 30. That writ petition number 19 of writ 20. It is 4 months I've given. They have taken action after 4 years. Cause of action 20th November 20. Page 55 and it's just 7, my lord. I have added separately in the compilation. It's a CBC guideline. My lord, I am prejudiced. Cause why the prejudice has been caused? I have been subjected to double punishment. I have been denied my promotion to the next higher rank. My lord, recently Mr. Chaudhary has got the award as the Vice Chief of the Army Staff Decoration. And for entire period, all the petitioners are decorated officers. They have got a high integrity, they have got an outstanding ACR, accepting this qualified the approach of the appropriate authority. Even my lord, lastly, Commander Colonel Kaushik Mitra, who has been left out with a simple one. He has not been born as a witnesses of the memorandum of charges. Who are the witnesses of the memorandum of charges, my lord? All the charge officials. See how they are denying my right to cross-examine my brother officer because they have already made them as a prisoner. When I contradicted them, they say, okay, can bring them as a defendant. Captain Vishal Mohan, with the medical officer, done the medical test of the 18 CPS multiplied by 2, 36 CPS. Now Captain Vishal Mohan was absent and they say, okay, and he has been made as a prosecutor witness. They said, okay, you make him as a defendant. It is a written submission, written awardment of the Union Opinion. This is my humble submission. Deeply obliged for the patient here. the judgment.
List of the judgments
Yes, my lord.
and the relevant paragraphs indicating.
That's all on this. Not quoting the relevant paragraph, my lord.
Paragraph number.
Give your opinion.
My friend cannot take up. Then, just after reading the judgment, there was a press briefing by the chief minister. On the death of the and Malafide was released. That would be a different case. Here it is not. Somebody releases Malafide. Puts a heavy burden on him to prove that Malafide and that person has to be made a part. This is not the case. Or as for other services regarding detail of justice is concerned, there we have been issued a show cause. We can, if we cannot bring a witness, we can cross-examine the witness.
Relevant-
That was in his favor. That was in his favor. So I do not present any witness.
Give your blessing.
But it's a 2015 method. So your losses will get off. Then you will be 7 May.
Then it becomes easier for what happens is that here now
After May, madam, Thursday or Tuesday. Pick a method.
because the earliest we can give you is 21st of
Technician in service, madam, she is the company secretary of Assam Industrial Development. Third company secretary from Assam. First was Kumpana Mountains. It was of my senior company. I have made my hearing
different courts, the number of occasions, for some reason, the matter remain inconclusive.